access to justice should never depend on your bank account. In the United States legal system, a special provision exists to ensure that financial hardship doesn't prevent people from having their day in court. This provision is called in Forma Pauperis. In Forma Pauperis, Latin for in the form of a pauper, allows individuals without financial means to access the court system by waiving certain fees. This legal status is available at both state and federal levels, though the specific processes vary by jurisdiction. The concept originated in English law, where a person too poor to bear the charges of suing could proceed as a pauper if they swore they were not worth £5 and obtained a certificate from a counselor stating they had a just cause. This person would then be permitted to have original writs and subpoenas without cost and counsel assigned without fee. Today, in Forma Pauperis serves as a crucial tool in ensuring that poverty does not preclude justice. The status is available in every state and at the federal level, with the notable exception of most bankruptcy proceedings. To qualify for in Forma Pauperis status, applicants typically must demonstrate financial need. Eligibility generally includes individuals receiving public benefits, those living at or below the poverty line, and incarcerated persons without significant assets or income. The application process requires filing an affidavit or financial statement that details your financial situation. This document typically includes information about monthly income and expenses, ownership of assets such as vehicles or homes, receipt of government assistance like SNAP or Medicaid, employment status, and number of dependents. In many jurisdictions, the fact that someone has in Forma Pauperis status is kept confidential. This protects the privacy of individuals who might otherwise feel embarrassed about their financial situation. It's important to understand what costs are covered under in Forma Pauperis status. While filing fees and docketing fees for appeals are typically waived, not all court costs are covered. Items like service of process, discovery fees, deposition costs, and expert witness fees often remain the responsibility of the filer. There's a key distinction between filing pro se and in Forma Pauperis. Pro se means representing yourself without an attorney, while in Forma Pauperis refers specifically to the waiver of court fees due to financial hardship. A person can be both pro se and proceeding in Forma Pauperis, but the terms address different aspects of the legal process. Legal representation is not automatically granted with in Forma Pauperis status unless the case involves criminal proceedings or rare civil rights circumstances. The landmark case of Gideon v. Wainwright in 1963 highlighted the importance of providing legal counsel to criminal defendants who cannot afford representation, cementing the role of in Forma Pauperis in facilitating access to the judicial system. Courts do exercise discretion when granting in Forma Pauperis status. Frivolous or repetitive filings may be dismissed even if the applicant qualifies financially. Judges may assess whether the underlying case has merit before granting this status. Corporations and other fictional entities are generally not eligible to proceed in Forma Pauperis. This status is reserved for individuals facing financial hardship. In Forma Pauperis remains a vital component of our legal system, ensuring that the courthouse doors remain open to all citizens, regardless of their financial circumstances. By removing economic barriers to court access, this provision helps uphold the fundamental principle that justice should be available to everyone, not just those who can afford it.